of facade and all their lies. Burn the corporate fiction to the ground. Shatter the chains that got us bound. Scream at the top of your voice so true. Tear down the walls and break right through. Rise up, soldiers of a broken world. With tattered banners, let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold. False promises and corrupt schemes. Rip the veil off the deadly dreams. No more silence, no more deceit. We'll take back the ground beneath our feet. Oligarchs with their greedy hands tight. Central banks stealing our night's light. New world order creeping in disguise. We see through a facade and all their lies. Burn all their lies. Break right through. Break right through. Rise up, soldiers of a broken world. With tattered banners, let your rage unfurl. Stand against tyranny that's deep and old. Power to the people, hearts burning bold. False promises and corrupt schemes. Rip the veil off the deadly dreams. No more silence, no more deceit. We'll take back the ground beneath our feet.
Good afternoon, good people of this neo-feudal corporate tax plantation we call Earth. How is everyone doing today? I realize it's a Saturday afternoon and it's absolutely gorgeous outside, so I don't anticipate this to be a high traffic live, but hopefully many of you will catch this on the replay. Today we're going to be discussing probably one of the most fundamentally important subjects in the distinction between law and equity. It's imperative that people understand this difference in order to actually be a student of the law, to actually be able to ask the right questions when you're in the courtroom, to be able to cause the prosecutor to stumble, the judge to stumble, because once you realize the difference between law and equity, it'll make complete sense how they're able to do what they're able to do in the courtroom, why juries are only advisory, why the judge is basically an 800-pound gorilla and the attorneys just want to give him a banana, because he's basically a god in the courtroom in equity. So we're going to discuss the distinction between law and equity. Plus, they just throw that term equity around. Diversity, equity, inclusion, DEI, right? And people have no idea what equity actually is. And put it simply, equity is when you're talking about property or finances, or it's your interest in something. And that's kind of the universal definition. I would say the most substantive definition is as you've acquired an interest in something, and that needs to be you need to be able to enforce an equitable right. But we'll get into that, right? And that's why it's left to the breast of a judge, because oftentimes it has to do with what's morally right or wrong, which may not necessarily be what's lawfully right or wrong. And I'll give some examples because I know that's confusing. But anyway, let me say hi to the very few people that have shown up so far. We have Mojo Shop. Good to see you, man. And Jace Ventura. Looks like those are the two in the chat. And we have about another 7 of you watching right now. And I'm sure people will pile in. I did set it up late, like basically 20 minutes before I planned on going live. So it's not like many people have had, you know, a lot of notice. So El Piro's with us. He says here in Iowa, see, he knows the difference between law and equity as well. He says here in Iowa, they no longer maintain a court of chancery and now have delegated the statutes as remedial for equity. Yeah, so we used to have chancery here in Michigan as well, and now it's just equity. Well, really, they just pretend like they're all courts of law. And so when you're talking to them and you say, "Is this a court of law?" We're like, "Of course it's a court of law," when in reality it's not. It's equity. There are no courts of law in this nation anymore. They were very careful to remove all knowledge of the distinction of law and equity from the public zeitgeist for that exact reason, because they can never abolish common law. All they can do is basically bury it and bar your access to it by making you a trustee of your own estate so that you only have equitable interest in even yourself. And to enforce equitable rights, you have to go to a court of equity. But before I even get into, yes, morality, chancery, and equity are similar. They're basically the same thing. The history of chancery was basically so you could go appeal to the king, pray to the king on matters of equity. And the priests got together and said, "Hey, king, we know you're real busy, so why don't you let me hold your conscience, right? And I'll act on your behalf in what they ended up calling chancery to determine these cases of, what's morally just." And so, and like I said, what's morally just may not necessarily be what's lawfully just. And I know that can be confusing at first, but by the end of the stream, you should have a good understanding of what I mean. So we got Chicago Cubby Bear in the house. Good to see you, man. So one of our moderators. I'll have to make you a moderator as well, Mojo. All right. So before we even get into any of this, I found this very interesting and highly accurate clip on X that I figure would be a good segue into our topic today. So I'm going to share this with you guys and let me know what you think in the chat. All right.
George Orwell once wrote, "Women are always and inevitably on the side of the state." He wasn't being misogynistic, he was making a psychological observation. In his view, women, particularly in their role as caregivers and moral enforcers, tend to prioritize safety and compassion over risk and freedom. And that instinct, while natural, is easily weaponized by totalitarian systems. When conformity is marketed as compassion and control is rebranded as care, the state taps into the feminine psyche to enforce ideological obedience. Now consider this. Men will do almost anything to attract a mate. So when the state captures women through propaganda, redefining tyranny as empathy and compliance as virtue, men follow, especially those who can't compete in the traditional dating market. They feminize themselves and trade strength for submission. This is what evolutionary biologists call the sneaky strategy. Low-status males mimicking feminine traits or moral positions in hopes of reproductive access. And while all of this unfolds, families disintegrate. Single motherhood, a top predictor of poverty and social dysfunction, becomes the norm. Children from single-parent homes are far less likely to climb the economic ladder, and who steps in as provider and protector? Not the father, the state. But here's the kicker. The state is funded disproportionately by men. So rather than supporting the women they married and raised children with directly, men subsidize the state, which in turn provides for women through social programs. Why? Because women have been propagandized to see every relationship as a power dynamic, except one with the state, which is ironically the centralization of raw power. They've been told that to rely on a man is weakness, but to rely on a bureaucracy is empowerment. This is not progress. This is dependency with a new face. And both men and women are suffering. The childless middle-aged woman and the incel are two sides of the same broken culture. A woman without her own child often directs her maternal instinct towards abstract causes, infantilizing minorities under the guise of social justice. What we are witnessing from psychologically unwell men and women is Nietzsche's concept of resentiment, envy dressed up as morality. The strong became evil, the weak became good, strength became tyranny. We now live in a pathologically soft society that sides even with those who harm it, where punishing crime feels unfair and victimhood is the highest virtue. Nietzsche called them the tarantulas, those who preach just from bitterness. They don't want to uplift the weak. They want.
Whoops, looks like we have can you guys hear me? Looks like we have a little bit of a internet issue, of course. Why not? Why wouldn't we? Hold on. Can you guys hear me? Let me know in the chat if you can hear me. Internet's been acting real funny lately, so I
want to uplift the weak. They
go.
want to drag down the strong. Orwell saw them too. Quote, most middle-aged socialists, while theoretically pining for a classless society, cling like glue to their miserable fragments of social prestige. These bitter, well-educated, and affluent types don't actually care about the downtrodden. They weaponize them. The real target is success, competence, independence, because those qualities expose their own inadequacies. But the answer to pathological femininity isn't pathological masculinity. It's not swinging the pendulum too far in the other direction. The answer is balance. Masculinity and femininity are not enemies. They're symbiotic. We've simply overcorrected.
Yep.
We escaped a world where masculinity once tyrannized femininity, only to arrive in a world where femininity is tyrannizing masculinity. We are not oppressed by patriarchy. We are being suffocated by pathological softness, envy, and resentment. And unless we recognize this imbalance, the future will not be free. It will be emotionally manipulated, morally confused, and biologically unsustainable.
Yeah, so that's exactly right. We've overcorrected. And it's a good segue into this discussion of law and equity, because what equity is kind of like the sister, the feminine. It's not law. So you'll hear me refer to it as part of law, but it's literally not law at all. It actually is complementary to law, much in the same way that men and women complement each other. Look at law as the masculine aspect, hard, rigid, and inflexible. And then equity is supposed to be its compassionate counterpart. And what it does is it supplies for deficiencies in law. And we're going to actually look to Blackstone heavily today. We're gonna rely on his works. William Blackstone. So every colonist had two books prior to the revolution in their home, and one was the Holy Bible, and the other was Blackstone's commentaries on the laws of England. And it's in four books, I believe it's two volumes, four books. Yeah. Yep. That's what it is. 2 volumes, 4 books. Fantastic. I've read 3 of the volumes. Great insight on the history of law and what law truly is. But, yeah, so it's supposed to supply for the deficiencies, and Blackstone goes into great detail with that, and also paints an excellent picture of what equity is. But prior to that, let me show you that this is constitutional, right? So we're going to just go to the window. I said share. There we go. All right, so this is Article 3, Section 2. Article 3 deals with the judiciary, right? And the entire Constitution is a subversive document. I'm not what you would call a constitutionalist. I think that we should have kept the Articles of Confederation for many, many reasons. Most importantly, that it left the back door open for the judiciary to usurp the sovereignty of the states, which is what Thomas Jefferson warned against and what has actually happened. But right here, it says the judicial power shall extend to all cases in law and equity. So it makes a distinction between law and equity, because equity is not law. Now, anytime you see the word law written in the Constitution, it refers to the common law. The common law is the original jurisdiction. Okay. Law cannot be written. It can only be written about. Okay. That's Blackstone. Beryl K. Spears said that, but Blackstone echoes the same sentiment. So common law is basically do not violate the free will of another person. That's it, right? So long as you're not damaging their property or violating their free will in any way, you are free to exercise whatever rights or expression that you want. Your rights basically end where another's begin. And it is all biblical. And Blackstone even agrees. It basically goes back to the Mosaic Law, 10 Commandments. You just can be summed up in the 11th commandment: do unto others as you would have them do unto you, right? And it really is biblical, so you can't get around it. As a matter of fact, there was one buttered biscuits has recently subscribed, and I spoke with him yesterday, and he actually gave me a great Bible verse that we'll look into. It's Hebrews 9, chapter 9, verse 16 through 22. We'll look at that in a little bit. I'm not a thumper, but it does apply. And the place where fact meets fiction, so where truth in law exists, fiction at law cannot exist. But there's one place in common law where fact meets fiction, and that's in the last will and testament of a deceased person. Okay? So you take that last will, that testament, and you treat it as if it is the living will, as if that person is still alive, and you act on behalf of them to perform their, the disposal of their property on their behalf as if they were living. So the entire body of law built around an estate not having the will, right, is where they have interjected and drug us into this realm of fiction. They presume all of us to be decedent estates. So basically, you as one of the people are missing, presumed dead. And then you, as a United States 14th Amendment citizen, are an infant pauper trustee of your own estate. And it's a decedent estate. And it's presumed there is no will for the estate. So the state is allowed to come in and administer the estate on behalf of the presumed decedent person, right? You as one of the people, and express that will on your behalf. And that's what they're doing. So let's go to Blackstone, shall we? So what is law? Let's start with what is law, right? So Blackstone, this is Blackstone Commentaries, book 1, section 2 of the nature of laws in general. And we're going to jump right down here. And he says, man, considered as a creature, must necessarily be subject to the laws of his creator, for he is entirely a dependent being. Now, dependency is what places you under someone else. And if you're independent of all other men, then you're still dependent on God. And so that's where common law comes from. That's the idea of common law. If you are independent, self-sufficient, and do not rely on any other men, then you're not under those men, but you're still under the law of the creator. So a being independent of any other has no rule to pursue but such as he prescribes to himself. But a state of dependence will inevitably oblige the inferior to take the will of him on whom he depends as the rule of his conduct. Right there, that is the very basis of administration. So if you accept welfare benefits of any kind by natural operation of law, you become dependent on that other person or entity. And so you give over your sovereignty, your controlling interest of yourself and everything that you own to the person on whom you depend. And then they get to dictate the use of your property. That's how they got everybody in the first place. If you guys seen my stream State of Dependency, I explained that pretty thoroughly. Even the 14th Amendment citizenship itself, even prior to the Social Security Act or any of that stuff, just by offering you privileges, immunities, and the protection of those privileges and immunities, caused you to be dependent on that federal corporation for quote unquote civil rights, which are not rights, and made that corporation your parent, right? So what they did was it was for the newly freed black slaves who didn't have any rights. And it's not because they were black, it's because they were property and because they did not know how to be self-sufficient. That's why, because even Andrew Johnson said in time they can learn to be free. And so the government basically just transferred them from being private chattel property to public chattel property via the 14th Amendment, saying we'll grant you privileges and immunities and protect those privileges and immunities and whatever other benefits Congress decides to come up with in exchange for you coming under us as basically an infant, as a ward. And then we get controlling interest of your estate and can use your estate as collateral, which is exactly what they did in 1933. And that's why the 14th Amendment was passed, because the United States federal corporation had no collateral of its own. Okay. Had no collateral of its own to borrow against. Sure, it could hire a central bank and delegate their powers of creating currency to that central bank, but they didn't have anything to borrow against, to borrow from the central bank. And so that's why they needed a class of citizenry of their own. Right. So Chicago Cubby Bear says there's a big fight for eminent domain in Iowa right now. Interesting. I'll have to look into that. Maybe put a link in the comments, man, and I'll check it out. All right. So he says, a being independent of any other has no rule to pursue, but such as he prescribes to himself, meaning you're not subject to anyone else when you're independent. But a state of dependence will inevitably oblige the inferior to take the will of on whom he depends as the rule of his conduct. And that's what the 14th Amendment does to the federal corporation. You become under the guardianship of the federal corporation. So not indeed in every particular, but in all those points wherein his dependence consists. So if you depend on privileges and immunities, then you're entirely dependent on them for life itself, basically. This principle, therefore, has more or less extent and effect in proportion as the superiority of the one and the dependence of the other is greater or less, absolute or limited. And consequently, as man depends absolutely upon his maker for everything, it is necessary that he should, in all points, conform to his maker's will. Okay, this will of the maker is called the law of nature. This is the very basis of common law. So right now, if you're just tuning in, we're learning what law is, right? For as God, when he created matter, he endued it with the principle of mobility, established certain rules for the perpetual direction of that motion. So when he created man, he imbued him with free will to conduct himself in all parts of life. He laid down certain immutable laws of human nature, whereby that free will in some degree is in some degree regulated and restrained, and gave him also the faculty of reason to discover the purport of those laws. Right. So essentially he right here. So yeah, this is the basis of common law. Considering the creator only as a being of infinite power, he was able unquestionably to have prescribed whatever laws he pleased to his creature, man, however unjust or severe, but he is also a being of infinite wisdom, and he has laid down only such laws as were founded in those relations of justice that existed in the nature of things and antecedent to any positive precept. These are eternal and immutable laws of good and evil, to which the Creator himself in all his dispensations conforms, and which he has enabled human reason to discover, so far as they are necessary for the conduct of human actions. Such, among others, are these principles: that we should live honestly, should hurt nobody, and should render to everyone his due, to which three general precepts Justinian has reduced the whole doctrine of law. And Justinian, as far as Roman emperors go, was actually not that bad. And his works are very insightful as well. So what is this saying? It's saying that justice is impressed upon your heart. It's essentially hardwired into you by God. And because of that, and this is the very basis of common law, why it doesn't have to be written, you know that it's wrong to harm or affect the free will of another. Right. So, yes. And as Alpero said, the law of nations, otherwise known as the laws of nature and her God. Yeah. Nature and nature's God. Exactly. And so the law of nations, when you look at that, you could refer to common law as the law of nations, the original jurisdiction. You could look at it as all nations being sovereign and co-equal. That's the underlying law, kind of like the operating system in the background. Right, that they all have to abide by in their discourse with one another, regardless of any kind of commercial contracts and stuff like that. The contract makes the law, and contracts are private law, right? So we're going to get into that. So that's essentially what law is. That's the foundation of common law. Now we're going to hop over to equity. So, where are we at? Clergy finding it remarkable. No, I think my bad, guys. So right here. Yeah. Okay. So, but lastly, so it's, let me see where I'm going to start here. Okay. So this is an example of where equity comes in. So, there was a law that those who in a storm forsook the ship and should forfeit all property therein, and that the ship and lading should belong entirely to those who stayed in it. And a dangerous, you know what, rather than reading in his old language, I'll explain this example to you, right? So where equity comes in, and it's complementary to law, it supplies for the deficiencies. And I've used this example before. Is say you have a ship, right? And this is what Blackstone's talking about. Say you have a ship and the ship's going down in the ocean, and half the crew members jump off the ship and the other half stay on the ship because they want to save the ship and its cargo, right? They're willing to risk their life for it. So they save the ship and the ship makes it to shore. And the ones who jumped off come up to the ones who stayed on and said, okay, we need our property. Well, the ones who stayed on said, no, we risked our lives to save this property. And so it's ours now, because if it wasn't for us, then the property would be at the bottom of the ocean. Well, law would disagree. Law would say those people whose property it is, who, you know, the ones asking for it, who, even though they jumped off, have never of their own free will conveyed this property to you. So although you did save it, and that's true, and although that without you, it would be at the bottom of the ocean, you're still violating the free will of the owners of the property according to law. Law is inflexible and rigid. Who holds the title? Who has ownership? Then that's who it belongs to. All other circumstances, they don't matter. So this is where equity comes in. Now the people who stayed on the ship and saved the cargo could go pray to the chancellor or pray to a judge. And this would take place in equity. They now feel they have an equitable interest in this property, right? An equitable right to it that can only be adjudicated in a court of equity. And their equitable right is the moral argument that if it were not for them, then that cargo would be lost. And that's what equity is. And necessarily, equity must be up to the discretion of a judge, who's supposed to act as a wise man to determine things like this, because it's outside of law. And because of this, all trust relationships and all contracts are adjudicated in equity, because it's determining the private law between the signatories to a contract or to those who are part of a trust arrangement. It's determining the terms of the trust and whether or not they were filled or breached. And all of this has to take place in equity for another reason as well, because anything outside of actual law is fiction. Contracts are private law. It's a fiction. Because law only deals in what is in fact. Nobody can partially own something, if that makes sense. So law cannot recognize I own this and I'm allowing you to use it, and you owe me this for using it and all this stuff, because that all becomes a world of fiction that we're creating right there. Law only recognizes what has happened or what happens now and what exists in fact. Equity deals with fiction. Does that make sense to everybody? So yeah, of course, Butter Biscuits. He said, thank you for taking his call last night. Absolutely, man. I enjoyed our conversation. So that's the difference. Now let's see what Blackstone says about equity. Okay. So right here, he's saying, oh yeah, here's the reverse side of that situation with the ship. Now say the ship's going down, because this is the other part of his example. Say the ship's going down and everyone jumps off the ship except for one guy who is too sick to jump off the ship. Okay. And somehow the ship makes it safely to port. That is an entirely different set of moral circumstances. Now, is that one person who is too sick to jump off, is he entitled? Does he have an equitable interest in the property? No, absolutely not. And so even though that's a similar situation, it would be the judge would rule on it differently. He would decide on it differently, and that would be up to his conscience. You know, we have this situation where these people brought the ship to shore and they had an equitable interest in the property because they risked their lives. It takes the judge to realize that they willingly, the judge will recognize their free will aspect in staying and risking their lives as giving them an equitable interest in the property, whereas law cannot do that. And then in the other circumstance where the guy was just too sick to jump off, that he did not use his free will to obtain an equitable interest in that property by saving the ship. He just couldn't jump off. So it's a totally different situation, right? And so this is what Blackstone says about it. From this method of interpreting laws by the reason of them arises what we call equity, which is defined by Grotius, the correction of that wherein the law, by reason of its universality, is deficient. So it's supposed to be complementary to law. says, for since in all laws, all cases cannot be foreseen or expressed, it is necessary that when the general decrees of the law come to be applied to particular cases, there should be somewhere a power vested of defining those circumstances, which, had they been foreseen, the legislator himself would have expressed. And these are the cases which, according to Grotius, lex non exacta, whatever, Latin, right? We're not going to translate that right now. But anyways, so this is very important. This is Blackstone's opinion of equity. And this is the situation we find ourselves in today, actually. Equity, thus depending essentially upon the particular circumstances of each individual case, there can be no established rules and fixed precepts of equity laid down, except for now our Supreme Court does exactly that. If we hop over here and we look at Federal Rule 2, one form of action, the civil action, right? So hold on. Boom. Conferring power on the Supreme Court to make rules of practice in equity. Well, that's totally antithetical to equity. So they're moving everything over to equity. And I'm going to get you to understand why they've been able to abandon common law courts. They can never get rid of common law, but now they don't have to hold common law courts or allow you act because you've been barred from access to common law because you have no real property rights. You have no actual ownership of anything. Everything is a collection of trust relationships in this country. Okay, so let's get back here. So it says there can be no established rules and fixed precepts of equity laid down without destroying its very essence and reducing it to a positive law. And on the other hand, the liberty of considering all cases in an equitable light must not be indulged too far, lest thereby we destroy all law and leave the decision of every question entirely in the breast of a judge. And law without equity, though hard and disagreeable, is much more desirable for the public good than equity without law, which is what we have today, which would make every judge a legislator and introduce most infinite confusion, as there would be almost as many different rules of action laid down in our courts as there are differences of capacity and sentiment in the human mind. And that is exactly what we have today. Everything's all equity because when you're being pulled into court, you're being summoned, you're being compelled to answer for your set decay use of property. That's actually what a summons is. So it was called a subpoena in Chancery, and I actually have the history of the subpoena right here. This is a practical treatise on the law of trusts. And so the subpoena came from when feudalism first began in England in the early stages of feudalism, which what is feudalism? It started in common law where all the nobles registered their property with the king. Basically, and they gave it to the king is exactly what they did. They gave it to the king and then the king gifted it back to them. So now at common law, the king is the absolute property owner of all the property. And now, because he is the owner of the property in a form of usury called usufruct, right? That's what usufruct is usury, usufructory. He gifted it back to the people who just gave it to him under certain conditions. And those conditions became feudal law. It says you're now using my property. So this property is tied to a title now. And the title is called baron, right? And as a baron, you have to pledge homage and service to me as one of the conditions, right? You have to give me a portion of your rents and profits of the land. And then you also have to supply me with knights. And then so the baron would turn around and give portions of his land to knights in what was called a knight's fee. And that would hold, that would come under certain obligations and circumstances. And so they're all holding the land in trust under the king, and the king gets to dictate how the property is used. And that became the new law. Right. And that's private law. It's essentially a contractual arrangement, if you want to call it that. And so that's where this whole jurisdiction of equity really started to take root. Chancery, it was called. And so you'll read right here. Originally, the only pledge for the due execution of the trust, talking about for the people under the king or under the baron, was the faith and integrity of the trustee, but mere feeling of honor proving as was likely when opposed to self-interest and extremely precarious security, meaning, so if somebody has the opportunity to cheat you out of your rents or profits or whatever, not do what they're supposed to do while using the land, their honor isn't a good enough surety to ensure execution, So An extremely precarious security, John Waltham, Bishop of Salisbury, a chancellor in the reign of Richard II, originated the writ of subpoena by which the trustee was liable to be summoned into chancery. There's that word summoned. And compellable to answer upon oath the allegations of a set decay trust. And that's what you have. That's so when you get a traffic ticket, you're being summoned to court and being compelled to answer for your set decay use of that property. Okay. And so you're not actually, you go, well, I didn't commit a crime. Why are you taking me to court or whatever? Well, it's because you breached trust is what happened. And this is being adjudicated in equity. And so that you're being compelled to answer, why didn't you use that property the way that we told you to? Because it's not your property. You're just the caretaker. You're the usufruct, right? Usufructory, which means that somebody else actually owns it. And well, in this case, administers it, because nobody owns anything. They administer it, and you have to use it the way that they dictate the property needs to be used. And that's expressed in the motor vehicle code, and that's expressed through property taxes. And all of this stuff goes back to the fact that your ability to own property has been stripped from you. As a 14th Amendment infant pauper, trustee of your own estate, your estate's entirely under administration in exchange for benefits. Okay, so your estate has been settled, if you will. That's what settlement means. And so your estate has been settled by the president and Congress in exchange for benefits such as Social Security, welfare, the ability to engage in commercial enterprise, for instance, when there is no money, right? And so your property rights have been mortgaged to supply, your estate has been mortgaged to supply for all those benefits. And so now that your property, all of your property is being held as in trust and used as collateral to secure the issuance of Federal Reserve notes and other debt securities. And as such, it's subject to administrative regulation. And that's what all of these, like the motor vehicle, DMV, Department of Motor Vehicles, is a administrative regulatory agency. And they're regulating the use of property that's held in trust. Now, all trusts can only be adjudicated in equity. I cannot stress that enough. Okay. And the reason the Bar Association wanted to do this is because in equity, well, let's read what happens in equity. Discretion, Bouvier's Law Dictionary, 1856, adapted the Constitution and laws of the United States with references to civil law and other forms of foreign law, because civil law is actually foreign to us here. So, FE Nation says, so if your car breaks down, can we send them a bill to fix it? No, that's your responsibility. You're taking care of the property. They just have administrative control of it. So they can tell you how to use it, right? Because you're an infant, pauper. So anyway, discretion. When it is said that something is left to the discretion of a judge, it signifies that he ought to decide according to the rules of equity and the nature of circumstances. Okay, yeah, sounds fair enough, right? The discretion of a judge is said to be the law of tyrants. It is always unknown. It is different in different men. It is casual and depends upon the constitution, temper, and passion. In the best, it's oftentimes caprice. In the worst, it is every vice, folly, and passion to which human nature is liable. That's why they wanted to pull everything into equity, because now the Bar Association can act as God. Think about that for a second. They can act as God by taking control of all property and reducing even you to chattel property of your own estate. They can tell you what to do with your own body. They can tell you, oh, you've got to get your kids jabbed up, right? Because they're actually the state's children. They're issues, right? Yeah, don't put those drugs in your body, little infant, right? Because they have to take care of the property. They tax it. So they have literally become gods. And this is important to realize, because man cannot make law. The only thing man can do is regulate commerce. And so this is something I was explaining to Brian Buttered Biscuits last night when it's like such a funny name. I feel weird saying it, but anyways, that's what I was talking to him last night about, is essentially you have laws and then you have statutes. Well, the laws are unwritten. They're only written about. That's common law. That's what law is. Statutes only have the force and effect of law when it is in concordance with law, or if you're under some sort of contractual or trust arrangement, which is why the motor vehicle codes and the revenue codes apply to you, because that is regulating the use of property held in trust. But in order to come under those codes and statutes, you have to be in that trust arrangement by consent. Now, law is just law. So let's put it this way. Man can only make statutes. That's why it's called statute. Statutes and codes. Now, if we're talking about public roads and I make a statute that says you have to have a license to drive on the road, right? Well, you have to be under some sort of contractual or trust arrangement with me, where I'm able to regulate the use of your property and say you have to have a license to use the property in order for that to happen. Otherwise, you can disregard it. But now if I create a statute and I say, if you murder somebody, you'll do 20 years in prison, or et cetera, et cetera. Well, now that doesn't require consent or any kind of trust arrangement to be subject to it, because that statute is in concordance with the law. And that's the only way that a statute can have the force and effect of law, is either one, you have agreed to be under it as the private law between two people in some sort of contractual or trust regulation type of situation, or it is in concordance with actual common law. And so it would be, it applies to you irregardless of whether or not you have agreed to come under it, because you're automatically under that, even in a state of nature. Right. So we got Brad and Tasha just joined us. Good to see you. So that is, that's the main difference between law and equity. So by moving everyone into equity, by reducing you to an infant pauper trustee, chattel property of your own estate, they have now essentially made themselves God, and made it because they regulate all the use of all property, including you as property. They now are able to be actual lawmakers, where there's actually, in all reality, only one lawmaker. That's God, right? So they're trying to make themselves gods on earth. That's what the Bar Association is essentially doing. That's what the Inns of Court, the temples, Inner Temple, Middle Temple, Lincoln's Inn, and Gray's Inn, they're trying to become gods on earth. They want everyone to be subhuman property, or even the word human is actually indicates us inferior species, right? It means monster, right? Human being means monster. So we are men and women. We are mankind. Very different from a human, right? Don't want to be a human. So this difference between law and equity, now you understand why there doesn't have to be a victim for them to bring you into court, because they're not bringing you into court to enforce law. They're bringing you into court to decide on someone's equitable interest in your property, basically, or whether or not it's a breach of trust arrangement that has been created with powerful investors. See, this is what I try to get people to understand. You are property. Not only that, but you're an infant. You think that what you say or think matters to these people. They know that you have no idea about any of this stuff, and they do. They're all taught this stuff in their families and in their private schools, all that. They know this stuff. They're the owners. You are chattel property. You are an infant. You can't make decisions for yourself, right? This is where we get the whole Title I, Section 8, and I show this all the time, but it's important, right? So on Title I, Section 8, Born Alive Infants Protection Act, right? So it doesn't want to bring up the, there it is. All right. Yeah. In determining the meaning of any act of Congress, right, or of any ruling regulation, that's talking about your property, or interpretation of the various administrative bureaus, agents, and agencies of the United States, the words person, human being, child, and individual shall include, which means at the exclusion of everything else, every infant member of the species Homo sapiens who was born alive at any stage of development. So you could be 50-year-old. And if you're a 14th Amendment citizen, you're an infant, no matter what. And this is why your vote doesn't actually matter. This is why Donald Trump acts as if he's your daddy, because technically, if you're a 14th Amendment citizen, he is your daddy, right? Parents patria, government is parent. So this is, and they appropriate funds against the mortgage of your estate. And it always has to be for your benefit because they're taking care of infant paupers, right? And I don't know if you guys get as frustrated as I do. Just think about these rich cocksucking Epstein Island traveling assholes in Washington, D.C. actually thinking that they're the only real people in this country and everyone else is a bunch of children, a bunch of infants, right? So I'm not going to stream for an incredibly long time today, but I was thinking about, I'm going to put the link, StreamYard link in the chat because it's been a while since I've opened up the stream to people, and I ordinarily don't do this, but if anybody wants to come up, I'm putting a StreamYard link in, and if you have any questions or want to contribute to this topic, El Piro or anyone else any of my jurists that may be in here, Mojo, that may know what I'm talking about. But this is how they were able to get rid of common law, because now you have no lawful interest in any property. You only have equitable rights. Okay, even your civil rights that are these privileges and immunities are your equitable interest in your own property, your equitable rights regarding yourself. When you really look at this thing in terms of property and property ownership, so in order for you to be able to enforce your common law rights, which are natural law, right, based on natural law, you have to have absolute ownership of whatever it is you're trying to enforce your rights against, basically, or for. And that includes yourself. So in your infant, pauper, chattel property of your own estate, you only have equitable interest in yourself. How's it going, Mojo?
Going good. Enjoy listening to it again.
Yeah, I know I kind of beat a dead horse with this whole thing, but it's so important to hear it over and over again to get it. Go ahead.
There's a lot to it. You really get into it, and B, you really need to hear it several times for some of it to really start sinking in.
Absolutely. And I see we got Carol with the K in the chat, International Truth Expo. It's a good opportunity just to announce again, I will be presenting this among other things, maybe even considering doing a workshop. I'm going to speak with Carol about this at the International Truth Expo, November 7th, 8th, and 9th in Quartzsite, Arizona. And as many people as could possibly make it out there, it's supposed to be an awesome event. I know Carol's going to have some music, and we're obviously going to have presenters. Mark Sargent's going to be there. She sent me a list of other people, but I'm going to leave that up to her to share. But there's going to be some big names there, and we're going to be camping, and it's going to be a lot of fun. So if you guys are interested in going, November 7th, 8th, and 9th, Quartzsite, Arizona. If you guys want to contribute to funding the event, again, I will put the link to the International Truth Expo website and their social media in the description once I get off here. And yeah, you guys can either donate or purchase tickets, or get all your information for the event. Should be a really, really good time. Mojo is actually the one who suggested me too, Carol. You kind of linked us up together, so I appreciate that, Mojo.
Brian, you know your stuff, and your message needs to get out.
I think the only way this will change is once we reach a critical mass of awareness. So what's happening right now is they're boiling the frog. They're slow boiling the frog. See, we reached a breaking point in this country because of the pandemic, over the last 5 years. And Donald Trump, while he's doing a lot of good things, economically and even societally, he's not going to give you your common law rights back. He's not going to restore your sovereignty, and he has no interest in doing so. His religion is money. Okay, which, hey, more power to him. He's doing great international business. That's supposed to be his only job anyways. But his only religion is money. He has no interest in you being in the image of your creator and all that stuff. I personally don't think he does. And so a great example of this is he just negotiated a deal with England, a good trade. It's supposed to be a historic trade deal, right? And he's all super excited about it. And I watched the press conference, and the way that he's talking, this one reporter asked him, so did you make it a condition of our trade our trade relationship that England stop arresting people for social media posts and restore their freedom of religion and all that? he hands it over to Howard Lutnick, one of his advisors, and Lutnick's like, yeah, no, we just discussed business. We were only concerned with business today. And then Donald Trump's like, yeah, the religion of business. And you know what? That was a true statement, because that's all they care about. It's their business, their bottom line, their money. They don't want the economy of the United States to fall, right? But it's up to us to actually restore the United States as a nation, as a collection, a confederation of states, not the corporation of the United States, but to restore these United States to their former glory. That's up to us. And the only way we can stop them from borrowing against our estates, right, and propping up the international banking cartel and regulating the use of your property is by learning this stuff. And it all starts with learning the difference between law and equity, right? So you only have an equitable interest in all of your property because your property is held in trust and you're the trustee of your own estate. So you don't actually have any real property rights. So with that being said, what you have to do is you have to reclaim your estate on the record. But when you do so, I'll never lie and tell people that there's a silver bullet. It's always going to be a fight. It's always going to be a fight. But by learning these things that I teach on this channel and that we discuss in the Jurist Society on our weekend meetings, you can be a real big pain in the ass for the system, right? So when you just even knowing this, the distinction between law and equity, okay, so you ask the prosecutor, you ask whoever it is that's trying to drag you into court, is this a court of law or equity? If they try to say it's a court of law, right, then you say, okay, where's the victim? Well, whose free will did I violate? Right, because that's a fact. That's what law is. You say, well, actually, no, it's for speeding or something like that, right? Okay, then this isn't a court of law. This is equity, right? So I need to see the contract or where I consented to be a part of this trust arrangement that you're trying to enforce here in this court of equity, because that's all equity can ever be for, is enforcing equitable interests and equitable rights. And if it's not a court of equity and it is a court of law, there has to be a victim. And just by knowing that distinction, being able to ask those questions, it presents a huge problem for the court. You say Article 3, Section 2 makes a distinction between courts of law and equity, right? Which one is this? What I need to know so I know what the rules of procedure are, right? And they can't. How do they answer that question? That question alone by itself is damning to them, So, do you get what I mean by that, Mojo?
Certainly do. They want the control when they don't like it when they don't get it.
So so this whole thing is regulating the use of your property. Let me see if I have this. I have something. Hold on. So right here, this is how you know you're under law. As El Perro said earlier, that you could call common law the law of nations, right? Not maritime law, but the law of sovereigns is what I personally like to call it. That's common law. It's the original jurisdiction. As Blackstone said, as I showed earlier in his book, that when one is dependent on another, that other person basically becomes their lawmaker to the degree in which the dependency upon that person exists, right? So if you say your entire survival depends on the state, right, you need retirement benefits and welfare and all this stuff, they've now become God to you. And you've settled your estate and they regulate the use of your property, right? I've actually got, before we even get into this Chisholm v. Georgia, let me show you guys this from the Avalon Project. I showed the jurist this last Sunday. So Mojo, you've already seen this, but this is the 1776 Pennsylvania Constitution, the original Pennsylvania Constitution on avalonproject.com. And let's see here. I think it's down here, 36, I want to say, section 36. He says, as every free man to preserve his independence, right, if without sufficient estate, ought to have some profession, calling, trade, or farm, whereby he may honestly subsist. There can be no necessity for nor use in establishing offices of profit, which are administrative offices. Basically, if a society or a certain group in society needs welfare, then this office of profit is created, right? And by accepting the welfare, accepting the benefits, you convey the controlling interest of your estate. Which, what is your estate, Mojo? Tell everyone.
You, your personality, and your soul.
It's your labor. It's your personality, labor, and property. That's what your estate is. It's your personality, labor, and property. And when you accept benefits, you convey the controlling interest of your personality, labor, and property to whomever is giving you benefits, welfare, whatever the case may be. Now, the reason it's called an office of profit is because it's up to them to figure out how to make your estate profitable. And then they give you a portion of that profit in the form of benefits, right? So say in England, it was workhouses. Looks like we got El Piro. What's going on?
Greetings.
How you doing today?
I am well. Thanks for having me up.
Yeah.
Good to meet you, Mojo. Spot on, brother. Spot on. A large portion of this is simply because people don't know how to communicate with each other. This is the public education system that indoctrinates us into a false English language. And I wish everybody would learn concise English. When you learn concise English and how it takes out all of the legalese, you will understand better what they are saying when you see legalese, and will be able to discern for yourself whether it actually applies to you or not.
Yeah, you mean what they call King's English, right? The King's English? Yeah.
Well, no,
Yeah.
Concise English. It was enacted in 1970s somewhere. And what it is we're taking, let me pull up a code for you.
All right, shoot.
Get screen share.
Yep. I'll take mine down for a second.
Okay.
All right, I see you.
Okay, this code here is federal regulations, Office of Personnel Management. That's what we're talking about under administrative management. We're talking about the civil services, which is the personal services that you provide unknowingly. And under this, we have a definition of federal government. Under federal government, in legalese, it says federal government means all entities of the government of the United States, comma. Then it's got this interesting term here. Now, I know you two on the panel might know what I'm talking about. It means it includes what's after and nothing else.
Nothing else. Yeah, it's at the exclusion of everything else. That's statutory construction 101. Yeah. So I try to teach people as well. Yep.
So when we look at this, we see that it's actually saying that the federal government means, and then you can exclude this part. And you will see that it says the federal government means the United States Postal Service and the Postal Regulatory Commission.
Oh, that's interesting.
And so what you see is everything's running under the Postal Service. Everything they account for is what? It's posted to a record.
Yeah, that's true.
And that's why it's registered mail, right?
Interesting.
So I have a hard time understanding why anybody argues with me on this, because this is concise English. Federal government means the United States Postal Service and the Postal Regulatory Commission. This
right, because the zone improvement program was the main, that is to this day the main federal overlay for territorial jurisdiction. Is the zone improvement zip code zone improvement program.
Correct. And no person shall reside within the zone except federal, state, or municipal officers or agents whose resident presence is deemed necessary by the board.
Well, let me see if I can pull this up. You'll find. So I've found, and I don't know if you've seen on here, but I've actually found, you know how hard it is to show to people the difference between resident and citizen, right? So I actually have a treatise called Elementary Law. I'm trying to find it real quick, where it lays out the exact difference between citizen and resident. And what you said, because as a resident, you're actually a
Agent.
you're federal personnel.
Right.
Your federal personnel, your social security number is considered a deferred retirement benefit. And so because of that, they can consider you federal personnel under the Buck Act, right? So hold on, I'm pulling it up right now. It should be open to the page.
Yep, just passing the buck.
Right. And so what the Buck Act does is it actually allows the state governments, this is how they get their slice of the pie. It allows the state governments to basically take guardianship or administer your property, and it allows them to introduce state income taxes, state property taxes, and all this. They're allowed to fine and fee the federal personnel for their use of their property. Here it is.
And I'm going to show you how they do that too. Go ahead.
The members of a state. So right here it says a member. And this is a fantastic book. It's one of the very few treaties that you'll find after 1913 that actually have truth in it regarding law. So members of a state, a member of a state may either be a citizen occupying the status entitled citizenship, or he may be a resident alien, right, occupying the status designated by the title resident. So you'll never hear a governor say Michigan citizens or Florida citizens, or you'll never hear a governor say that. They always use the term resident, right? And so a citizen is a permanent member of the state, owes it allegiance at all times, and is entitled to its permanent protection, whether he's at home or abroad, right? He says that it's the status of membership is distinguished by its permanent and personal nature, and may be determined by his place of birth, jus soli, which is the law of the soil, I'm sure you know, and by the nationality of his parents, jus sanguinis, which is the law of the blood. By his election or by some form of naturalization. A resident alien, on the other hand, is a person residing within a state other than the state of which he is a citizen. He owes the state sojourn allegiance and is entitled to its protection during his stay. The status of his membership residence is distinguished by its temporary and local nature. So as a United States citizen, you're federal personnel, you're a citizen of the District of Columbia, and as a resident of your state, you're a foreigner there temporarily, right, for the purpose of engaging in commercial enterprise on behalf of your home state, which is the District of Columbia. And that's how they look at you. That's it. And so if we pop over here and we look at see if it pops up. Here we go. Section, case text. Did you know they took case text down, by the way? Interestingly enough, let me search my favorites real quick.
Yeah, wondering if that's part of you.
Yeah, I wondered also, actually. Resident. Well, anyways, if you look in the Michigan compiled law, because all I have apparently are the case text references, and case text is no longer here. But if you look in the Michigan compiled law and the motor vehicle code, resident is defined as a person who resides in this state, in Michigan, and establishes that he or she is legally present in the United States. And that's the term that it uses, legally present, right? So let's see, where was that Chisholm v. Georgia that I had up? So this right here, this case is one of those cases they hate people to bring up, right? Because this is 1793. This is Chisholm v. Georgia, okay? And it explains the difference between common law in Europe and common law here in the United States. And what it specifically says, if we go up here, it says, at the Revolution, the sovereignty devolved on the people, and they are truly the sovereigns of the country, but are sovereigns without subjects, excluding the African slaves at that time, he says, and have none to govern but themselves. The citizens of America are equal as fellow citizens and joint tenants in the sovereignty, right? And down here later, it says that that basically the government's relationship to us is that of a lord or tenant to the king. So it's our servant, it's under us, it's a trust that we created. So the way that they pulled you from this top status of being the grantor of the government trust and being above it and independent of it and not subject to it whatsoever, the way they pulled you down is they created their own ens legis, their own creature of law. And that's the 14th Amendment citizen. And when you adopt that status, now you're a creation of the creation of a creation. You're all the way at the bottom of the ladder. Would you want to show El Perro on regarding that the Buck Act or the federal personnel you had said? You had something you wanted to share. You're muted, bro. There you go.
There we go. So it's up in the background. This
Let me
is
see. I got you.
Okay. Again, when it comes to the Postal Service, some more language to look at, and it says the Judicial Officer Department is a neutral, independent forum within. Does that sound like Chancery? The United States Postal Service, consisting of the Judicial Officer, the Office of Administrative Law Judges, and the Postal Service Board of Contract Appeals.
That's
Why
interesting.
is that? Why is that? That's because everybody's been indoctrinated in the public education system to write down the legal name first and last, along with the street name and its securitization number in a agreement with the local municipality who named the street and the Postal Service who enumerated it. And then it's expressing the trust, city, state, and zip, of which you are the agent. You're the custodian of record. How many tax records are you going to keep? How many driver's license records are you going to keep? How many of their records are you going to keep while identifying pursuant to the driver's license? And I want to explain, if the individual's name and social security number identify the social security record, then would it not be logic and reason that the individual's name and driver license number doesn't identify them? It identifies the record, the driver's license record. If the student's ID and number is an identification, it does not identify the student, it identifies the record.
Right. Well, even more so, what's being identified is the estate. So the Social Security numbers, or the Social Security trust, is the underwriting investment trust. That specifically is what you are the primary trustee of. That's why all the property, all your real property, and even some of your chattel property is linked to your Social Security number, like your vessel, your vehicle, right? And the driver's license, the registration, and the plate are linked to your driver's license, which is linked to your Social Security number. And this is where people have to understand money or the lack of it. All we do is trade contracts as currency. Okay. So in 1920, they made the Treasury independent so it could represent both sides of the contract. The Secretary of Treasury represents the international banking system, and the Treasurer represents the United States as debtor. Right. And they're two signatories to essentially a mortgage contract. Now, all contracts, especially mortgage contracts, which we know it's a mortgage contract because they said so March 9th, 1933 on the congressional record, that it represents a mortgage on all property. So in order to have a mortgage, you have to have what is mortgaged is the collateral, right? That's what the term mortgage means. Now, what has been collateralized is your estate, and they use that as the primary surety to generate all commercial paper, which is debt. Currency, right? And that's what our fiat currency is debt currency, commercial paper. So when they bring you to court, they're not bringing you to court, and they're not bringing a corporation to court like people like to say. What they're doing is they're bringing an estate to court, and you come in as chattel property of the estate, as the trustee, or like he said, the agent of the United States and the trustee of the estate. And they're calling you or summoning you to court to compelling you to answer for the set decay use of the property that you hold in trust, but they administer because you're an infant pauper. So Marilty, or I think I said it right, Marilty wants to know if you have any resources you can recommend to study the construction and concise statutory construction and concise English. Statutory construction, I can say personally, is difficult to find. Something that you learn by basically reading statutes. I haven't found a treatise on statutory construction. Maybe El Perro has. But the concise language, I think. Go ahead.
Well, the statutory constructions, we have to understand, they aren't enacted. What? What?
Right. Yeah.
There's no enactment clause as required by the Constitution? Goodness gracious.
It's because they're not public law anymore. It used to be public law. Now it's public policy because everything is just regulation of the use of property.
Which is contract.
Yes, absolutely. But see, the way that pull you into the contract is it doesn't require your consent. They do it through presumption by using. So when we created this country and when we became independent,
Well, I tried to usury. It's that usury you were talking about. It's known as an imperfect usufruct. Go ahead.
Yeah, we didn't create a new law. We continued to use English common law, but what changed and made it American common law was that we were not subjects of a king now, like it said in Chisholm v. Georgia, like it says right here in this court case. We're sovereigns without subjects, right? We're co-tenants in sovereignty, but we still use English common law. But it's like we're all kings and queens, right? Well, what happened is they didn't have to actually pass any legislation to do what they did because it was all grandfathered in with English common law. What I mean by that is the Settlement Act, the Poor Laws of the 1600s, and the Set the KV Act of 1666 were all grandfathered in. They never had to legislate any of it. So then by presumption, through operation of law, you accepting benefits, especially with the 14th Amendment, they were thereby able to presume your infancy and dependency and take administrative control of your estate. So there never had to be an actual contract. It's implied consent, or like you said, imperfect usufruct, just by the very act of becoming dependent on the federal government for privileges and immunities and later welfare benefits.
Right. And again, it goes to the public education system. Remember, our forefathers taught their children both contract law and trust law, as well as the Constitution language and everything. So what we've got today is a public education system that doesn't teach our younger generations how to establish these trusts and everything and how they work, so that when they become age of majority, they can recognize it for what it is. And it's merely learning how to record your own estate. This is mine. It's not the state's. It doesn't require a certificate of title because it's mine.
Right.
So they have to establish what the estate is and keep the property of the estate private and understand the term of property. Let me see if I can pull that up. Actually, it's on I don't think I can.
Well, property, yeah. And the word estate is what confuses people a lot of the time. The word estate, when you think of estate, they think of like some stately manor with, big house and large property. No, an estate is your personality, labor, and property. The poor dude begging for change on the corner of the interstate exit has an estate. His estate right now is the clothes he's wearing and his ability to labor. That's how people were able to enter into trust indentures.
Your property itself explains and expresses the estate as it is merely by comprehending that it encompasses all real and personal effects. In other words, the tangible and the intangible.
Like intellectual property, for instance.
So in American jurisprudence, it's actually defined, and I'm not going to say it verbatim, but it's pretty much succinctly, it is the interest and rights of the enjoyment of the possession and use of a thing for one's benefit. That's it. And when you look at that, it's not naming the thing, it's the rights and interest of the possession and use of it for your benefit.
I've got a good thing to pull up on property, actually, and I love this because it ties it so this guy J.G. Warner, this is called a Treatise on the Law of American Administration, right?
And that's why it's important to understand that usufruct, because that's what they're doing, is they're using your property improperly, and that's your intellectual thoughts. They've got you thinking you're a resident. You're not a resident by their definitions.
No, absolutely not. But the way this guy breaks it down, I think it's 2 volumes, and this is a must read for everybody also, right? With Blackstone's, like I said, I've read the first 3 volumes of Blackstone's. Well, rather listen to the audiobook, and that right there will give you a great understanding of what law truly is, municipal law, what law is, and then you have municipal law, which is kind of like the blending of like public policy, public law. It's basically the law under which a society lives in its entirety. So if this thing ever freaking loads,
is that on YouTube as well to listen to as an audiobook on there? Where is it?
Blackstone? Yeah, I listened to it on YouTube. I listened to it while I was at work. Over the course of a couple weeks, I'm on volume 3 still, but then really volume 2 is probably the best. Well, volume 1 too, because he gets into what is the nature of law. If this freaking thing will ever open.
I'll start from the beginning. I didn't know. I actually didn't realize it was on YouTube. So
yeah,
good.
So like, for instance, even over in England prior to William the Conqueror, even though they had a king, they had a allodial title. You'll learn that from Blackstone's Blackstone's commentaries. It was William the Conqueror who caused all the nobles to register their land with the king. And when they registered their land with the king, they, damn, this thing is not wanting to open. Maybe I have too many tabs open or something. When they registered their land with the king, under common law, the king became the allodial title holder, right, of all the property, and thereby he was thereby able to regulate the use of that property. And like Alpero was saying, that's what became the feudal law, right? That's what became feudal law. The feudal law was merely the king's regulation on the use of the land that he now held in allodium. And so, but my point in saying that is that even them having a king was a social contract that was acknowledged, actually, when they ousted King James II. They ousted King James II because he was giving England over to the church. And they said, you're violating the trust that we have given you. Basically, you're violating the trust agreement between us as our king. And so we have the right. It was an unwritten law. It wasn't written before, but it was, because that's the whole thing. Common law itself is unwritten. It cannot be written. It can only be written about, right? So yeah, apparently this thing's not going to open. But what he says here is, he says that property is that which is mine. My property is that which is mine, right? And he says, it's that which I acquire to serve my will. By my will, I acquire property to serve my will, as my bodily limbs serve my body. And he says, therefore, property is the ultimate realization of your free will. Okay. And that's why it's the basis of all law. Free will is the basis of all law, and it manifests, its highest manifestation in this world is in property. You choose to acquire something according to your taste, the taste of your personality, basically, and you labor towards it. You put sweat equity into it to make it become yours. He says the very nature of matter is to offer resistance. So by your will, you overcome that resistance and you make that property yours. And so it's the ultimate expression of your free will. And when somebody else has superior interest in the entirety of your ability to even acquire property, as in your estate, finally, they actually have control over your free will. Your free will has been probated, as our friends over at VSOF like to say. Your will has been probated, and that's the truth. So we'll get down here. This is there's a lot of...
And real quick here, if I could insert here, see, yeah. This is where we have freedom, which is your inherent free will, which exists no matter what. That's inherent freedom. Then you have liberty, which is spoken about in the Declaration of Independence and the founding documents. That's because you're one of the subjects, known as one of the governed or one of the governing, under that trust indenture. Then you have your rights, which are your contract rights at the civil venue. And well, that's what Burn the Corporate Fiction was talking about. Once you find yourself in that civil aspect, you're in deep, and you got to find your way out. It's deeper to dig out. That free will is your inherent spiritual nature to be able to do all that without the person. You don't need that third person intervening.
That's actually exactly right. And so this is interesting. So this is called the Treatise on the American Law of Administration. Notice it's dealing with property. He says in here that the sphere of the law is entirely spiritual because it operates upon and through the will alone. So this is how it starts to get into spiritual biblical. But what you'll notice is that Michigan, and their compiled laws of 1929, it's 1846. I pulled it up the other day, but in their compiled laws, yeah, look, you'll notice that the very first document they list, and this is why law was never written. So common law was never written. It was considered actually an abomination to write law down because it gave man the opportunity to lie. And this was something that the people of the English Isles, of those isles, inherently knew. So when the Magna Carta was created, people like to tout the Magna Carta as like some amazing charter of liberty that did wonders and led to the creation of the Constitution, which it did. But just like the Constitution, it's a double-edged sword and a subversive document to be used against the ignorant. Because what the Magna Carta did is it infected common law with Roman civil trust law. And so if you read the Magna Carta, almost the entirety of the Magna Carta is dealing with inheritance, descent of property, and the administration of intestate estates, meaning estates without wills, and the administration of estates where the heir is a minor. And that the Magna Carta laid out all the rules of how, the administrators would get paid, what their responsibilities were. They had to maintain and take care of the property. They have to return the property to the heir once he comes of age, but they're allowed to collect a fee for administering it. And that's what introduced this whole concept of the administration of decedent estates or infant estates into common law. And so you'll notice that's why in Michigan compiled laws, 1929, the very first document in their preliminary chapters, this is their listing of jurisdictional authority, is the Magna Carta right here. And that's why, because they intended on using the law of administration to usurp the sovereignty of the people. That was the intention behind this country from its inception. The courts, the judges, the Bar Association, ends of court, they had this problem over in England. There was that pesky Pope and that pesky king. And so they could use the sovereign powers of the king. But if the king was in the same room, then they automatically took a back seat because the king was the sovereignty, right? They wanted to get rid of that. So how did they do that? They inspired the people over here with the concept of personal sovereignty. And they made the people sovereign, knowing that people are inherently not very intelligent, especially if you can take control of the education system. And over time, they would be able to usurp the sovereignty of the people. And that was the intention of the Bar Association the entire time. When you read the old statutes in Michigan, you can see that was their intention, because they started immediately issuing settlement certificates, bringing in immigrants and people who'd be dependent on the government. Right away, that's what they started doing, right? So it's right here, Magna Carta, then Declaration of Independence, then Constitution of the United States. And another little known fact is that the Articles of Confederation is still in full force and effect also, because the Constitution didn't create the states. The Constitution did not create the states. The Articles of Confederation did. And that is what our union is called. It's a Confederate Union. We got Penn Hollow versus Doan's Administrators. I know I have it up somewhere, but it says that when an alliance right here. So, but wherever an alliance, and I can't highlight. Oh wait, yeah, I can. Wherever an alliance is not corporate but confederate, the sovereignty resides in each state. Right now, the state retained all powers which she did not expressly surrender to the union. A state cannot cease to be sovereign without its own act, nor can sovereignty be asserted but upon a clear title. Right, that's very important. So that the entire structure, Michigan's a Confederate state. They're all Confederate states, and people don't realize that. And the reason is because the sovereignty resides in the state, because the state is the people. It's not the government; it's the people, and the people are sovereign. That is what the state is. The government of a state is the government of a state. That's not the state.
And
the
so
state
goes the same with the administration of that estate that was created for one of the people. That's the same situation. And the administration is just not known. If it's known and people learn how to manage that estate themselves, they would do much better. I would urge people to get them out of the public education system. This information is imperative, not just for us, but for the future generations. We need to start teaching them this stuff, folks.
That's why I have this channel. That's what we do, is where we've got to, because that's exactly right. The way that you become free isn't by getting acknowledgement of freedom from the government. It's actually by learning how to manage your own affairs, learning how to manage the affairs of your own estate, and not accepting benefits or protection from some sort of governmental or corporate entity. because then, like Blackstone says, you come under whomever it is you depend on, and the degree of dependency determines the degree of authority that entity has over you. That's what Blackstone says, and that's a fact. And so right here, this is for the property, El Pero, is my property is that which is mine. That only is mine which I acquire, hold, and dispose of by my will. It is my will. And when you read the Magna Carta, you'll read, and a lot of the articles actually start off, we will that it be known. So this all comes back to your will. It's the same reason why they have to show you what they're going to do to you before they can do it, because they can't violate your free will. That's what revelation of the method is all about. And this is the preliminary law that they have to, people go, oh, they do whatever they want. No, they still have to follow the law, the actual law. And they know that.
And that's why they backed off on this whole COVID crap too.
That is exactly right, because people weren't buying it. And then also the Second Amendment didn't hurt either. That's why we didn't have drones flying around checking to see if we were outside of our quarantine zone, because people would have been picking them out of the sky with their rifles. Mm-hmm. So he says, it is my will which determines the acquisition of a thing by me, whether originally by reducing to possession and thus making my property that which was no one's property before, or by contract, which a thing becomes mine through the concurrence of my will with that of its former owner, right? And and then he starts to get into, he says, since I cannot, and this is an interesting way to look at it, since I cannot rightfully acquire the property of another without his consent, that is, without his free will, it is obvious that the will of the original owner is a necessary element in my ownership, and that the ownership of anyone who may lawfully acquire it after me, and remains operative until the property has lost its character, as such by voluntary abandonment. By my own free will, I may abandon my property. So think about that. By them not allowing you to dispose of your property, even to sell it or get rid of it or abandoning your property is an expression of your free will. And if they stop you from selling or abandoning or disposing of your property in any way, they're violating your free will. It's an interesting way to look at it. So it says, where by my own free will, I may abandon my property, whereupon it ceases to be such and relapses into the condition of res nullius, subject to become property by the sole will of any person who acquires it. And that's the source of all abandoned property laws, right? And so, let's see here. I hold or use a thing which is mine at will. Matter is unfree. It has no will. It does not belong to itself. Neither right nor duty can be predicated of a mere thing. Its quality is to offer resistance. It is therefore negative to my will. My will, in realizing itself, overcomes this resistance and subjects the thing to its purposes, changing its form, destroying, consuming it. That which is mine is thus a part of my personality of me, insofar as its end and purpose of existence is the satisfaction, the realization of my will, and to serve it for its purposes as my bodily limbs serve me. Now, I want to note that this treatise is a treatise on the American law of administration. Administration is only ever referring to trusts. And specifically what this book is about how someone can be declared incompetent, or all the different ways that property comes under the administration of the estate. So if you're a drunkard, a spendthrift, a lunatic, if you're missing, right? If you die without a will and there's no immediate heir to claim your property, right? Or if you die, even if you have a will, but the heir is not of age, the state gets to step in, which is what the crown used to do in England. And this is an operation of common law because of the Magna Carta. This is what infected it with this concept. The state is allowed to step in and take administrative control of your property, because the heir, like in the instance of where the heir is not of age, then he's not capable of exerting his free will, and they have to protect and preserve the property. Or in the case of you dying without a will, which is what they presume everyone to have done, then the state gets to come in and express your will on your behalf, supposedly for your benefit, or how they presume you would have expressed your will. But of course and it's for the maintenance and care of the estate. And so once a property comes under administration, the judge has license to sell or mortgage any part of it, as long as it's for the benefit of the estate and the property of the estate. And that's what they've done with with the bankruptcy in 1933 and mortgaging your estate. So they're when they appropriate funds, they're borrowing against your sweat equity, and it's supposed to be for your benefit. So what do? They create a bunch of NGOs, non-governmental organization, nonprofits that are supposedly supplying these beneficial services for you. And then they place themselves on the board or at the head of it, or they contract with, their family, and then they funnel this public money that they've appropriated against your sweat equity into their own pockets. That's the name of the game. And it all has to be for your benefit. So it all has to be philanthropic, if you will. And that's what Doge was uncovering, was all this basically how they're doing. You know what I'm talking about, El Piro?
Oh yeah, it's
yeah.
I just put a comment down in the chat about maintenance versus champerty, and when we look at that definition and understand how it affects the estate and how you stand up for the estate, you'll see how they twisted everything in that imperfect usufruct. They handed you something to use. They took your name and gave you a number. There was an exchange there, but you didn't understand it.
Well, even more so what they do. So when you registered when your parents register for your birth certificate, they're abandoning you by documentation. Okay. So you immediately become an orphan, and a bastard orphan at that, which is why they put your mother's maiden name on the birth certificate, not her married name. So you're a bastard orphan at that. And because you are an infant now under administration, you've been registered, this property has been given over to the state, because that's what registration is. Anytime you register something, you're giving controlling interest over to whomever you're registering with. That's what the Doomsday Book was with William the Conqueror. Everyone registered their land in this land survey book, and by doing so, they gave it to the king, and then the king gifted it back out to them. So they have to create a title to your estate, and that's what the birth certificate is. In order to be able to mortgage the estate or borrow against the estate or do anything with the estate, there has to be an estate. Now, you're given basically what is a certificate of title, which just shows an ownership interest in it, but not ownership. Because as El Piro so astutely commented earlier, if it's yours, there doesn't need to be a title to it. There only needs to be a title to it when more than you have interest in it. Then, because title certificates just represent a portion of interest in the property. They don't actually represent ownership to the property in general. It's just a portion of interest, an equitable interest, if you will, in the property. And so that's how they originally get you. Then when you sign up for the Social Security number, right, that Social Security number makes you a 14th Amendment citizen and a trustee of the Social Security Trust that all your property is to be linked to, because that Social Security Trust is the underwriting investment trust. It underwrites the entirety of the debt of Congress, is the Social Security Trust.
And if you understand underwriting, that's insurance. Insurance is prepaid, and tax assessment has to be done to determine the tax to be paid upon transfer.
Yep. And that's why. So once you realize that the Social Security number is an underwriting investment trust, and like he said, it's insurance, that's why they always have to have an account number that's linked to your Social Security number. That's what your driver's license number is. That's what the plate number is on your car. Everything has to be linkable to the Social Security number so they can generate securities. Okay. When you realize, it's revolutionary. Once you realize what the currency we use is, what the meaning of debt security is. All debt security is, you've got the Securities and Exchange Commission, right? The two pieces of legislation that birthed this monstrous security scheme is called the Social Security, or the Securities, the Securities Act, and then the Securities and Exchange Act, right? And so Securities and Exchange Act defines trading securities as buying and selling. So now just by trading debt, they can say you're buying and selling according to that act, but you're not buying and selling. You're trading debt, right? That's all.
Yeah. And and they've got something in there. I think I've got it verbatim here. A person presumed to be an eligible contract participant.
Yep. And that's,
you're presumed just because you were born here.
Well, it's the registration originally, in my opinion. That's the linchpin, because that's the common theme going all the way back to William the Conqueror. And all of this does stem from William the Conqueror, this whole feudal, because what we're in now is a neo-feudal version of the same thing William the Conqueror set up, just more advanced and commercialized and digitalized. That's it. But it's neo-feudalism, make no mistake. That's what, because the corporations, the counties specifically, act as feudal lords, and your tenants on land that they actually hold the superior title to, and they charge you property tax, again, for your benefit. That's a fee, the same thing as like a knight's fee or a baron's fee. That's a fee. Your taxes are your property taxes on the use of that land, and in exchange they must offer you benefits, and those benefits come in the form of fire department, police department, infrastructure, and all these things are considered benefits for you, right? That's what millages are. So it's like a pretend philanthropic thing where they're like, oh, well, we're taking care of you, so we have to charge you this fee for the use of the land, and we hold the absolute. Because I'll tell you exactly how they took the land. It used to be a lodial title in this country. Wisconsin Constitution, Article 1, Section 14, I want to say, says that all lands are allodial and feudal tenure is prohibited. Well, what happened was this guy named Alfred Torrens over in Australia came up with the concept of a national registry, land registry system. And then we ended up adopting it here in the United States. And now it's called something else, but the registry already took place under that system. And they sold it to the people and to the attorneys on ease of transfer. It makes it easier to transfer your title, because before you had to go and you had to draw up a deed, and then you had to have witnesses to the deed who actually witnessed the sale, and they signed the deed. Then you file the deed on the public record, and then the person who purchased the house files an acknowledgement of that deed, and now the sale is final, and all of that goes into the land record regarding that piece of land. And then anyone who has interest in it in the future, they can go look up and trace the chain of title all the way back to the original land patent. Well, with registry, they're like, we only have to be concerned with the person who currently is registered to the land. And that's all we don't have to trace. We don't have to pull an abstract or do any of that stuff. So the attorneys were all about it. But what really happened was all of the land was given over in trust to the United States, basically. And now they're the feudal lord over all properties in all states. And they can charge just in the same way the king charged a fee for the use of his lands. That's what they do here now, is charge a fee for the use of the lands. So it's that damn registration that does it every time. And so right here, just to continue real quick though, will then is the essence of property. Without it, there is none. Hence, that from which I have withdrawn my will, which I have abandoned, ceases to be my property and becomes, as we have seen, res nullius, the appropriation of which by another is no violation of my right, because it is no collision with my will. If then I wish to preserve my property, or which is the same in effect my right to it, I must indicate in some way perceptible to others that it is still subject to my will. Otherwise, I may be understood as having abandoned it. To avoid collisions arising out of misinterpretation of my relation to a thing, a definite period is fixed, and this is where you get into abandoned property laws, right? So it's important to understand that everything they do is constitutional, and it is under common law. That's where it all starts. Right. But this right here is a doorway, what I like to call a doorway in common law. And you can go out this door, right, into administration, which is its own body of law. And that body of law is purely dependent on the conscience and will of the person who administers the property. They dictate the use of the property. That now becomes your new law. Right. So the last thing I wanted to show you guys on this document and see what you guys think, because everybody thinks that law is separate from the Bible and from spirituality, when in fact nothing could be further from the truth. The judges would like you to think so, because they're all satanic fucking PDFs, but it's not true at all. And in fact, in ancient times, the lawyers, the lawgivers were the priest class of pretty much every society, and the bankers, because the temples used to be like in ancient Rome and ancient Greece, the temples used to be the ones who minted the currency. and they would put the head of whatever god or goddess, their temple is dedicated to on the coin, in the same way that we have George Washington's head on the coin now, right? Which, then that evolved into being Caesar, which is what George Washington actually represents. But right here it says that property then is the realization of the free will of a person, the external sphere of his freedom. As such, it partakes of and is clothed with the dignity and inviolability of the person. The things which constitute property can have no rights, for they have no will. That's what happens when you're chattel property. You have no rights because you have no will. You have privileges and immunities, and will alone, or the person in which it has its abode and vehicle, can be subject of right and correlative duty. The law recognizes and deals with the property only insofar as it recognizes and deals with the will of the owner, realized or externalized therein. For the sphere of the law is the spiritual. It operates upon and through the will alone. That's what you're literally witnessing in today's age, and you're starting to realize by learning the stuff that we teach on this channel, that this is truly a satanic inversion of law that we're witnessing with the commercial system. Do you guys care to comment on that? Anyone?
Total agreement. That's all I can say. Absolutely.
Well, like I said, when you look up American jurisprudence definition on property, you'll see the same language.
Yeah, and
they've got 16 different cases on it.
That's what's funny, because I'll give you a couple examples. I'm going to shut this down shortly, but I'm going to give you guys a couple examples. Right here is a great WordPress on the settlement certificate, because that's what your birth certificate actually is a settlement certificate. Like I said, they grandfathered these settlement acts and poor laws in with common law and never had to pass any legislation, because it was taken for granted that these things were part of the body of common law, right, from England. And then so they still took effect here. And I'll even show you. So we go down here and they're talking about, so here under Charles II, the concept of settlements as plantations of working poor controlled by the Church of England was further refined through the Settlement Act and Poor Relief Act, including for the first time, the issuance of settlement certificates equivalent to a birth certificate, passport, and Social Security rolled into one document. A child's birthplace was its place of settlement, and this is one giant tax plantation of working for. There isn't a bunch of different corporations. There's just one big corporation. Because who decides the labor laws and who decides how a company can treat its employees and what the pay scale, how they've got to deal with time off and benefits and all this stuff? Who does that? The state does that. The state passes enactments that tell the companies how to deal with their employees, because it's actually all just one big corporation. It's one big tax plantation. That's it. And so we go down here a little bit more, and it says, let's see here. Got to find this one quote that you guys will find interesting. It's
well, and another interesting aspect here is that it applied up until you were 16. A child could work his service off up till he was 16. Today's modern age, they don't get the opportunity to do that. There's no evidence that they've worked off their service. So the young men are supposed to sign up for military service.
Right. Well, this is interesting right here. It says, if a person entered a parish in which he or she did not have an official settlement and seemed likely to become chargeable to the new parish, then an examination would be made by the justices or parish overseers. From this examination on oath, the justices would determine if that person had the means to sustain himself. The results of the examination were documented in the examination paper. As a result of the examination, the intruder would then either be allowed to stay or would be removed by means of what is known as a removal order. This is English law right here. This is Settlement Act and Poor Relief Act stuff. This is what this set up. Now watch this. I'm going to hop over here to an old Michigan revised statutes from the 1800s. And remember where it said if somebody came in, so it says if a person entered into a parish which he or she did not have an official settlement and seemed likely to become chargeable to the new parish, then an examination would be made by the justices or parish overseers. Check this out. that if any overseer of the poor of any township shall have reason to believe that any stranger who shall have come to reside in such township and who shall not have obtained a legal settlement therein is likely to become chargeable to such township, such overseer shall apply to any 2 justices of the peace of such township or of the county in which the person shall live and inform them thereof. And the justices, being so or otherwise informed or suspecting such stranger to be of insufficient ability or likely to become a charge to such township, are hereby authorized and required to issue their warrant to a constable of such county, thereby commanding him to bring the stranger before them. And it's the same thing. It's the same exact thing. This is what they're using. It's the settlement laws, the poor laws, the Set the KV Act to take administrative control of your estate and treat you as chattel property, as an infant pauper trustee of your own estate, which brings you into the jurisdiction of equity and bars your access to common law because you only have an equitable interest in everything. But isn't that insane? It's almost the exact same wording.
Well, you know, the Sedicate Trust Act was in 1666. I've got something in the background for you. If you want to pull mine up.
Yep,
This is the 5 Mile Act of 1665. Now, what else happened in 1665? Wasn't that the Great Fire?
That was 66, but yeah.
66 was the Great Fire. 64 was the plague.
The plague, yep. And see, it's funny you bring that up because that caused mass death, right? And that's why they passed it, because now we're just going to presume you're dead unless you come forth with an action and prove yourself to be living. We're going to presume you to be dead. Your estate is now intestate without a will, and it's going to come under the administration of the crown. And then what did they do right after that, El Piro? Created the Bank of England.
Oh, yeah.
Perfect Hegelian dialectic.
Yeah, good old London gold surveyors.
Right. So he was able to take all of these estates that just came under his direct administration via the Set the KV Act and use it as collateral to start the Bank of England and start borrowing from that Bank of England using all of his subjects that are presumed dead and under his administrative control through Chancery. He's now able to use that as collateral to borrow against. And that's how they do it. It's wash, rinse, repeat. You go back to Emperor Nero, and with the consent of Senate, he burned Rome to the ground. And then afterwards introduced the 12 tables, which said the same exact thing. It's wash, rinse, repeat. They continue to do the same thing over and over again. We're going to presume you're dead unless you come forth and state yourself to be living. And if you don't, then your property's under my administration, basically.
And they've been telling you the same thing over and over, and they just do it in different ways. As we read here, the 5 Mile Act, or Oxford Act, or Nonconformist Act of 1665, was an act of the Parliament of England passed in 1665 with the long title, An Act for Restraining Nonconformists from Inhabiting in Corporations.
Interesting. Huh.
All you gotta do is learn how to read.
And the big thing is once you learn these fundamental concepts at law, right, in law, because here's the thing, the reason that you can look at the acts from, or regarding the descent of property and stuff and administration from the 1600s, and it's the same in the 1800s in Michigan, in a totally different country that adopted English common law, obviously, but this is after the revolution, obviously, where the people are sovereign. The reason all of this stays the same is because this body of common law is, again, it's not written, it's only written about. And this is an interpretation of how to deal with people who are dependent on you, the poor of it, but they still do it according to the dictates of reason and common law. You can look at the 1215 Magna Carta and go all the way up to the Northwest Ordinance, and it uses the same wording, the same principles, and the same laws, because common law, that's why the attorney needs to pull you into equity in commercial law, because the attorney can't make law. Right? Men cannot make law. The law isn't written, it's only written about. But they can make contracts. So by the act of pulling you into commercial law and under administration, where they can regulate the use of your property as they see fit, they're usurping the just powers of God in being able to control you by making what they call law. But as we all know, that law is not law. It's the regulation of the use of property. It's the only way they can get you. And it only has the force and effect of law, or the color of law, if you don't either rebut the presumptions or you consent to it. And that's the thing that people get, well, I never agreed to it. I never consented. Yeah, but you also didn't withdraw your consent either. And that's the operation of law regarding consent, is it's negative, really, right?
Well, yeah, you're presumed to be acting in the same capacity because you didn't say otherwise. And if
Exactly.
nobody knows it and the paperwork says it, it's still the paperwork. So if you're out there filling out official documentation, you're acting like an official. That's their job. All you have to give them is the data elements. Well, I'm not a United States citizen. I was born just soli and just sanguine, and my parents on the soil. So I am an American. I don't know how you guys want to classify that, but that's your estate. That's not mine.
Right. Exactly. You created that. That's you. Whatever that is, that's yours. That's not mine. And that's the big thing about it. That's the whole point, is the people created the states. The states created the federal government. The federal government created the 14th Amendment citizen. The creator can never be subject to the created. It's the simplest way to look at it. So you can never be subject, as one of the people, you're not subject to the state government. You can only be subject to a jury of your peers at law with a victim. That's it. Not the state. It takes literally fellow sovereigns to both indict you and convict you of a crime, and a crime requires a victim. So as one of the people, that's where you're at with that, right? Only other sovereigns can try you and convict you. Then the state is, of course, sovereign above the federal government, as we read in Penhallow v. Stone's Administrators, reserved all powers they didn't expressly give to the United States, and will not cease to be sovereign but upon its own act. So it's above the federal government, right? The federal government created its own creature, the 14th Amendment citizen, and then drew everybody under that umbrella. And now, as a 14th Amendment citizen, you're a creature of the creature of the creature.
Yes, I was born a non-14th Amendment American, and
Right.
I was conferred, otherwise gifted, the use of a United States citizen pursuant to being a resident at the state level.
Right.
I have the use. It's qualified, but it's imperfect. It's imperfect.
Exactly. Imperfect user fraud. And this right here is a good point too, is that you said you're an American. Well, specifically, your nationality is your state. That is a country. That's why you look at England, or you look at Italy, or you look at France, and they're like the size of a state, because that's what a nation actually is. What the United States federal corporation is, a super state. It's the European Union. It's the original European Union, or what the European Union is, right? It is a collection. It's a confederation of states in a union, right, that was corporatized with the 14th Amendment after the Civil War. And it became a corporate union with the federal government as the headquarters, basically the headquarters, corporate headquarters. And all the states became administrative departments of that federal corporation. And of course, the federal corporation is the welfare daddy to all the states, which is how it keeps them under control. But that's not how it's supposed to be. And your state is actually your country. Look at the wars. Like Michigan went to war with Ohio. What army did we use? We used the Michigan Army. We used the Michigan militia. They used the Ohio Army. Even at the Civil War, each state conscripted its own military, because that was they each are their own country. And so I'm a Michiganian, right? Mojo, I think you're not a New Yorker, are you? But anyway, your nationality is whatever state you were born in. That's your country.
Right. An Iowan born on American soil.
Exactly. You're an Iowan.
So.
And by being an Iowan or a Michiganian or a New Yorker, South Carolinian, or whatever you happen to be, that's your status as one of the people. Say, I'm one of the people. I'm a Michiganian. That automatically makes you one of the people, right? You don't have to use the term citizen. You don't have to say any of that shit. You say you're either, like he said, I'm an American citizen, or I'm whatever state you are. And that's actually in the, what do they call that? The Oxford Manual. They had the list of nationalities according to each state at one point in time. And it listed them all. These are the different nationalities. And Michiganian, New Yorker, Iowan, whatever the case may be, they're all different nationalities. But Anyway, I'm going to shut this down. I appreciate all you guys for coming on here. Do you guys have any parting words for the chat or people that watch after?
Thank you as always for all the information. Really appreciate it. Y'all have a blessed day.
Hey, you as well, Mojo. You as well.
Take care, Mojo.
Anybody else?
Yeah, I just want to urge people, don't ever believe anybody. Don't believe me. Don't believe burn the corporate fiction. Don't believe the neighbor. Don't believe the government. For crying out loud, don't believe your mother. Do your research.
Yes.
So you know. Understand that we've been educated the wrong way. We've been educated to remember things instead of having logic and reason to look outside the box with abstract thinking so we can come up with remedies ourselves. That's what this entire system lacks, is the remedies we need, because it only provides remedial actions for them.
It's all
That
theory.
Exactly right. And
do your research.
It is, and we have to come up with solutions using the established law, which is common law. We can come up with solutions together, figure out how to reverse engineer, which is what we do. But it requires you to study, like he said, and I don't believe researchers that I come across on the internet. I need source documents. That's what I provide you guys on this channel, is source documents. I show you where to look. I give you the links, tell you what's going on. And I don't expect you to believe me. Read it for yourself. That's why the description's truth supported by facts and evidence. So what about you, Brian? You got anything you want to say?
Well, real quick here, I just want to back up what you just said, and then I'm out. And just like I showed you with that 5 CFR code, you got to learn the concise English so you can break it down and see what they're actually saying. Federal government means United States Postal Service and Postal Regulatory Commission, people.
Absolutely. Yeah, I'm actually going to look into that myself. What about you, Brian? Oh, Brian took off.
Yeah, no, I'm here. Yeah, just thanks again, man, taking a call. And I've been, like I said, listening to what you've put out there. So appreciate everything too. But it was just a really long week, as I kind of mentioned to you. So I'm pretty tired myself. But as El Paso, El Perro, he was mentioning, it's Romans 3:4, basically that kind of sums it up, which is let God be true and every man a liar. So do your own research, man. And
there you go. I like that. Yes, absolutely.
So, absolutely. Bring it back, and you'll find out once you understand logic and everything else. I truly believe it's written on people's hearts, and there's, when you're doing something against the logic itself, you're going to find yourself in a conundrum and trying to deal with all these other fallacies and logical cognitive dissonance and all this other stuff that we're all involved in because of the way we've been programmed. But once we can get this down, it takes care of a lot of other issues in your life too. But we're like Brian's saying too, I'm at the point that I'm basically counting the battles that are coming forward. I'm at the point that I'm ready to move forward with this, but who goes to war without first counting the cost itself? So we all know this is going to be a war that you're going to have to fight, and your freedom is worth fighting for. And it's not that freedom that we've been sold in school and everything else, that we all just stand up at a ball game and sing to the national anthem and say, "Oh, God bless the troops for saving us," when no, they've actually been enslaving us, doing the exact opposite. It's each one of us is a sovereign and our own king, and we have our own will, and nobody else can go against our own will, and we can't go against anyone else's. And once you can learn that, then I think this world will be a lot better.
Yeah,
so that's but
we are all equal before the laws of nature, and nature's God. Right? We don't have equal capacity, but we're all equal before the law, and that's the point.
That's it. Absolutely.
Well, all right, guys. Thank you for joining me today, and thank you everybody in the chat for watching. And I will tomorrow, if you're watching this on the restream and the playback in Jurist Society tomorrow at 4 is our meeting. I know we have a new member, so I put it in the comments, and then hopefully you're still watching. Let you know it's tomorrow at 4, and I'll see you guys then. And to everyone else, I will see you next week. So you guys have an awesome day.
Take care. And you'll probably have another one by this evening or tomorrow. I'll go ahead and sign up too. All right.
Yeah, that'd be awesome, man. We'd love to have you. So,
All right.
all right.
Appreciate it.
See you guys later.